process in filling board vacancies. We just don't, at a board meeting, say, oh, we like this guy, so you're on the board. We ask for candidates. We have people make a position. We interview candidates, and then the board votes. Now, let's face it, a board that has a certain objective is not going to pick someone, probably, who objects to that. But they are going to invite everyone to come forward and apply and use the normal process. So the United Board really, last year, had a whole of 5 people. And they stepped forward back in that time frame, and I had to go through an interview process and whatever, and I became one of the people that took a 3-month vacancy, and it went on, and that's what you do. And what we do here is really is atypical from a normal board, because back east where I practiced my management practices, more often than not, you have a vacancy, the board would just sit down and they'd say, you know, I know Phil wants to serve. Okay, let's appoint Phil. And that was it. So here we're way more open, and they're just facing reality. The low assessments that we allegedly have in United really were the responsibility of boards going back to 2011 and 2012. This board came in later and essentially were putting together budgets for later time periods. And so it's kind of like blaming Bush for everything that the Obama administration does. The lawsuit is not a myth. With a refusal to honor the legal bylaw amendment that was passed by the Corporate Members Council, with a refusal to mediate the question, there was no choice but to file a lawsuit. I think Judge Melman, who is one of our United people, 52 years law practice, a judge, he said, that's how you resolve disputes. Sometimes you have to resolve disputes that way. So that's something that was done with a purpose. As we've discussed, the real issues of recall, it challenges the monarchy of the majority of 6 directors. Further amendment of the bylaws, if we were to make other amendments other than the one we just did, could result in a direct election. They see the writing on the wall. There's such a sentiment in the community, not just in United, but throughout the community, for direct election. No matter how you do it, whether you do it by a popular vote, you do it this way, you do it that way, there's a sentiment to go in that direction, and they don't want that. It obviously, if we had direct election, would stop the pre-selection of candidates being elected to support specific agendas. And I'll just review again, the corporate directors vote the directors for the GRF, which simply means that if you have a number of directors in a given mutual who have a policy, who have an agenda, they want to ban dogs, let's say, and they'll ask someone who's on that agenda to run for GRF, and they'll put all of their votes behind that person, so they'll now get a person on GRF who hates dogs. It works both ways, to be fair. You can use the same process, the same kind of backroom politicking to get good people on GRF. You could put votes together, back candidates, get agendas selected, but that's really not the right way to do it. I mean, that's really not a democratic process. It's, I said in my last presentation, it's more like the Vatican. You wait for the white smoke to come out of the chimney, and okay, we have new board members. So the fear of direct election is just huge on the part of these people. And of course, there aren't a lot of credible answers that these people can give explaining the conduct of the Golden Rain Foundation board members. So getting a mere 300 or 400 people to file a petition to do a recall is obviously putting, you know, an 800-pound gorilla in your way to just put a stop to it and try to cut it off at the neck. When PPV did their petition, which wasn't a petition to do a vote, it was a petition to the board members to kind of wake up and look at the number of people who wanted something. So it had no economic consequence. They had over 2,000 signatures. And I told them at the time, petition doesn't mean anything unless you're asking for a special meeting or whatever. And of course, they gave them that 2,000 plus member petition, and the board threw it away. And they did themselves a disfavor then when we actually changed the rule and they got other people to file a petition to eliminate the rule through a vote. And that's when 70% of the community voted, and I think it was 69% approved the rule that had been passed. So it really exploded on them, totally. The lawsuit and the recent minute order that has been published by Judge Glass, that's kind of a current thing. This thing that EIEO or whatever did the other day, that's even more current. The thing is that the bylaws were amended back in 2006, and there were 5 restrictions placed in there at that time. So it's not like we're doing something new. It was amended again in 2011 that had to do with meeting attendance by other board members. The 5 restrictions added in 2006 were, as we discussed, and this I came in the aftermath of issues like selling the property for the old administration building, the stable issue, whatever. A vote required on creation of new mutuals. Vote required on sale or lease of GRF properties. Vote required on acquisition of real estate. Notification required for new facilities construction. Notification required for demolition of facilities. These were the two. This was the 2006 amendment, plus the one in 2011. At that time, many of the current opponents, Sousa, Gerson, Rosenaft, Wilson, actively supported those amendments to GRF. They were concerned about GRF. Now they're on the other side of the fence, not concerned. Attorney Bob Hart of Hart, King, and Coldren did not view the amendment process as illegal or in conflict with the trust back in 2006. To be fair, he didn't like it. He said, oh, this could get in the way of GRF doing their business. But he didn't raise any objections legally. Whoops. I need to get this off of here. Oh, escape. Thank you so much. I'm an idiot on PowerPoint. None of the other association attorneys, and everybody had their attorneys, raised any issue with the bylaw amendment process at the time. Now, we obviously have a conflict because the Corporate Members Council voted legally, following all the procedures in the bylaws, to take those last 2 restrictions that we saw, where you have to notify the members when you do something, to require a vote. So it was a very subtle change. It wasn't earth-shaking. And they made the change, and GRF said, well, we don't recognize that because it's a conflict with the trust. And we have sole power or sole discretion, and therefore we don't like your bylaw amendment. What's changed since 2006 and 2011? Those 5 restrictions got voted in then. We made a slight change now. Some of the people were on the other side. It wasn't the concern over GRF's power because the 5 restrictions back in 2006 came in because of a concern over what GRF was doing back then. Now we have the Recreation Master Plan, which is like a lightning rod, mainly because of the size, the enormity of the project, 18.8 million, or whatever it's at today. And you know, there's a difference between making a bad mistake and a horrible mistake. A bad mistake is if I back down a driveway and I take out your mailbox. Horrible mistake is if I back down the driveway and run over your dog. How do you live with that? This project that got done kind of under the radar is a horrible mistake, and we'll show why. The GRF power is threatened, obviously, and it's not like they have a mandate. They only have 6 people. We have 5 people on the other side. That's hardly a mandate. It's like when Bush won in his first election. He didn't have a mandate, you know? And, you know, this is not a mandate here. So some of the people who were on the other side against GRF power, who are now on the board, had to flip-flop to defend their actions. It'd be interesting to hear the personal stories of how those people voted in 2006 to restrict GRF and are now over here saying, no, you can't do it. Famous quotes. If you like your plan, you can keep your plan. This, the RMP, will cost you nothing. We're going to talk a little bit about transfer fees, because that's really at the heart of where a lot of this money is going. Back in 1987, Davis Sterling prohibited transfer fees, and that's because there apparently were abuses, and I think they were by management companies. When someone bought a new manor or a new house or whatever, they'd be charging $500 for the papers, then it'd be $800, and it was pretty abusive, so they just stopped it. GRF consulted with a group called the California Consulting Group regarding an amendment to allow transfer fees. So some of our money at that time went toward getting a lobbyist, basically, to help us. And a 2000 amendment to the Davis Sterling Act allowed community interest developments, us, GRF, under a declaration of trust to charge a transfer fee. So GRF is under a declaration of trust. In the state of California, you can probably count on your hand the number of HOAs that are under a declaration of trust. So this was a handcrafted lobbyist bill that got through that then allowed GRF, but not the mutuals, to charge a transfer fee. And then in August of 2011, there was a GRF release that stated how the fee would be placed in reserve funds to reduce member assessments. Now, from that standpoint, it's a good thing. And I'll also say, people will say, well, it's not a transfer fee, it's a facilities fee, or it's this or that. Well, transfer fee is a generic term, and whether you call it an initiation fee, a membership fee, capital fund fee, whatever you call it, it comes from a transfer of real property. So it's a transfer fee. You can call it something else. So it was implemented on January 1st, 2012. And should have been good news to most people. July 2012, Friends of the Village newsletter stated that the fees are to be used for maintaining our amenities. More good news. PCM then recently announced an increase to $2,500 from $1,500, and then stated it would be used now, watch the wording, to enhance and improve the recreational and other amenities. GRF president previously stated, well, enhanced was used in order to agree with the trust agreement. No such term is used in the trust. So we have a subtle shift from maintaining, and to be fair, they did say maintaining and improving. So it was kind of a dual purpose with the fee. We're going to maintain and we're going to improve. Well, part of renovation is if you're doing a gym, you get newer treadmills, you get newer machines. That's improving. I'm not sure that an $18 million structure is improving. This was put in by my helper, John Giles, who's down here in the first row with the straw hat. And as you know, I'm a PowerPoint idiot, so he was putting this together for me. And he had to put that in. He said it just occurred to him, and I thought, why stifle, emotion? So we're keeping it in, Sean, and thank you. Okay, well, let's talk about the real financial cost. And this is what floats my boat. I mean, we have all of these issues about governance. They did this, we did this, they did that. But to me, it boils down to the dollar. First of all, you see the little piggy there? That's the annual GRF reserve contribution. All of our reserve funds have what's called a reserve plan. And a reserve plan is a 20-year plan that looks at the life of all of your assets, and it determines how much money you must contribute each year in order to keep the money in the kitty and have enough money to replace, renovate, and go forward on your amenities. So the GRF reserve for 2013, this is from the audited financial statements, was $4.5 million. And all of that money came from the members, us. The buyers down here, people who bought manors, the facilities fee income was $1.5 million. And in 2012, that sat on the balance sheet. It was not used in any other way to reduce reserve contributions. It essentially, it didn't go away. It was in a restricted fund. It sat on the balance sheet. In 2013, a hunk of that money that was on the balance sheet was used to pay principal on the loan. Per the statements we get from GRF. It wasn't used for maintenance. It was used for principal on the loan. If we look at it this way, the cylinder, the green cylinder, that shows the $4.5 million that we contributed for the reserve, the GRF reserve. If the $1.5 million from the transfer fee had been contributed as part of that $4.5 million, you see that it shrinks by 1/3. What does that mean for us? It means that we would have to transfer 1/3 less. Okay, so it's a savings. So instead of us putting out $4.5 million, we put out just over $3 million. That savings then is something the mutual can utilize. Now, it still requires a smart board at the mutual. And the smart board would say, oh, that transfer fee saved us a bunch of money. We're not going to lower the dues. We're going to take that money and we're going to put it in our reserve fund. And if we were able to do that in 1 year for United, it would give $761,000 that could go into the United Reserve Fund. For Third, $735,000. For the 50, $36,000. In 2 years for United, that's $1.5 million. So when the opponents are saying, well, you people keep your assessments too low, you have dry rot, you have sewage, you're not keeping up with all your maintenance, well, my God, if they did what they said they were going to do with the transfer fee, we would have an annual savings each year that could be applied to our reserve fund so that we could tackle some of these problems. So if this money is now gone, if it's going to go to principal and interest for the loan, calculate this out over 15 years. we're talking $22 million. That's at the $1,500 level. Now at $2,500, I haven't even calculated because I was looking backwards rather than forwards. So if I came to you today and said, someone stole $25 million from us, everybody would be up in arms and you get your pitchforks out. But this is basically what's happening. And to me, this precedes even talking about the recreation plan, and whether we have an outdoor amphitheater, whether we have an indoor swimming pool, whether we have this or that, or whether that report was right, or was this report right? How about those engineers, that architect, those designers? Central point is, if it's not financed properly, forget about that. Let's get back to basics. And transferring the money each year as part of the GRF reserve fund is a win-win, because it lowers, uses the money for what it was intended to, and it gives a savings to each of the mutuals. So this is just a huge lost opportunity cost. And then we'll talk about the lawsuit just a little bit, because obviously people are making assumptions about what that means or what that doesn't mean. The information we have now, which concerns the temporary restraining order and the preliminary injunction from Judge Glass, was just on that issue. Just on that issue. That judge did not hear the full merits of the case. There weren't oral arguments, there weren't written arguments, and it's very likely another judge would hear the case. There's another issue, which is all of that stuff that came out of the preliminary injunction, it's not evidentiary at a trial, which means it does not enter into the judge's decision at trial. It's excluded. It has no force. It has no merit. Having said that, if it does go before Judge Glass, we have a little bit of an inclination as to where he's headed, and could he be convinced otherwise? We don't know. But it's not dead. It's not a 50-50. It's probably more like a 50-50 if we do go to trial. Either way, what we were going for was not to win and kill someone, but to get a clarification of the issue of trust versus bylaws. In law, that's called a conflict of laws issue. And if you go to a law school class, they're going to be reading cases about a man's paddling a kayak on a flooded highway and a car hits him. Which law applies? Is it maritime law, or is it criminal law, or is it vehicular law? There's an issue. One of the questions that came up at the hearing were along the lines of, what's the conflict? And the conflict in the minds of GRF is that because the trust gives us sole discretion, whatever you do, we can overrule. And that's not a conflict. A conflict is the trust says you allow proxies at this type of meeting. The bylaws say you don't. Well, which one prevails? If you get a clarification where the judge finally says, this is superior to that, you then say, well, that's superior, so that rules. You have to have an issue. And if you don't have an issue, it's really a specious legal argument. And in the case of a bylaw amendment, only the 27 directors vote. It's their discretion that is being employed. GRF doesn't vote in a corporate members thing. So they have no discretion to exercise. So obviously, if we do go to trial and have a favorable ruling, that's a shorter path to amending the bylaws as necessary, getting direct election or other things we think are necessary. Unfavorable ruling simply means a longer path. It means replacing people, getting responsible directors, and doing what you need to do. And really right now, community sentiment will direct our further actions. If the board is not recalled, that kind of tells you where the sentiments are in the community. The future. The recall is successful Prepare for 10 more years of an unaccountable GRF runaway train. However, 10 years out, we have Armageddon, end of days. I feel like a preacher now. When the trust expires, and it has an expiration date, it must either be terminated, renewed, revised, or replaced, per the Paul Hastings legal report. Remember, we had a legal memorandum from the Paul Hastings law firm that was to explore the conflicts between the trust and bylaws. My takeaway was this paragraph. The GRF trust appears to be an antiquated and fraught with inconsistent record-keeping, irrelevant exhibits, tax analysis filings, and references that are no longer relevant. It appears that the GRF trust was a trust formed for construction and construction lending purposes only. This was the law firm that looked into it. But at the end of the days, all 4 corporations must agree together to do an action. Any one corporation can be the spoiler. 50 could be, United could be, GRF could be. We don't agree. And if you can't get 4 corporations to agree, it could terminate. If it terminates, then you get into that silly scenario about dividing assets up, and I don't know where you go with that. That truly would be Armageddon. So is renewal of the 60-year-old document in the best interest of anyone? It is if you're the GRF monarchy and wants to retain your power, your sole discretion. Now, I have a home in Atlanta, and when I come here, I have a landscaper. I give him discretion with my lawn. I'm gone for 5 months. If I come back and see a $60,000 swimming pool in my backyard, I'll shoot him. I didn't give him that kind of discretion. And I think what we have with our trust, it's really like a trust from hell, in that it's for the benefit of us, the beneficiaries, and it's like we give them a gun and they shoot us in the face. And currently, only the United Board is prepared to work towards this objective. Now, if they prevail and are not recalled, and we obviously have enough people on the other boards and enough people in the communities, we go through elections and stuff, the hope is that we have 4 boards that finally sit down and say, let's cooperate, let's get together, let's look at this end of years coming 10 years out, let's look at issues on governance, so that we don't have these 4 corporations here that I call the planetary method. You have Jupiter, Venus, Mars, and they're kind of floating around, and there's no connection between them. And the only connection with GRF is, well, we run this thing at our sole discretion. And we've always been told by them that, oh, you're represented by your directors. Because your directors are on the Corporate Members Council, and so they get to vote on your behalf. Wrong. They just did a bylaw amendment. And they're saying, no, 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 no. So how are they voting on your behalf? They were being disenfranchised. So basically, truly, the 13,700 members have no vote, no representation, 0. So, if you are uncomfortable with imprudent financial decisions made without open debate and discussion or any accountability, oppressive media policies and secrecy intended to stifle any honest debate, I saw Pat English's video where she criticized something, and she was a model of decorum. And compared to some of the vile stuff you're seeing from the other side, and for that she's being sanctioned, it's unbelievable. Meeting agenda manipulation. The whole thing on raising the fee to $2,500 was listed as a policy discussion. And before people blinked an eye, there was a resolution, it was voted on, it was a done deal. And to this day, I've never heard why they did it or what they're going to do with the extra $1,000. So that's just bad. So if you're uncomfortable with where the money's going or not going and this governance model, which is awful, vote no on the recall. My name is Mike Comer, and I approve this presentation.
Thank you. Wow. This is really wonderful. Don't you guys like it? I tell you what Mike has outlined is really a very clear path for all of us to follow. You know what that conclusion might be? We got to run in the coming elections, okay? Let's put back the majority with census to third, united, and GIM, okay? And I know we'll take a little longer maybe for the mutual 50, but I'm sure they'll come on board. But let's do it. With all of you here and all our board members, we'll get there, and we will be there. And I think it's only right, after almost 50 years, we start have a normal structure, a normal way to listen to the majority, listen to the people voices at least. If people like a gym, let's give them one. But if they don't like it, don't build one. That's simple, right? Thank you. Thank all you coming tonight. This morning, I'm sorry, I didn't sleep last night. We have a question session. Good news is we have about 10-15 minutes. So if you have a dying question, we got one already? Okay. Let's get some of the mic here. And also, if you want to state your name and your manner and who you question might direct to, okay?
My name is Cheryl Beldner. I'm in 203C. I don't have a question. I have a takeaway for you. It is important for you to know the agenda and where people stand when they're running for election. Know where they stood and the decisions they made before. Know what they've got on their mind. We have a person